Welcome to the No Excuse to Miss podcast. I am your host, Scott Volquartsen. This is the No Excuse to Miss podcast. This week's guest is the executive director of the Second Amendment Foundation. He's been involved in the 2A community on many levels, including managing an FFL, writing for publications such as Recoil, and hosting a YouTube series, just to name a few things he has done. Welcome to the show, Adam. How are you doing?
Good. Thanks for having me, Scott.
I'm glad you guys could make it. Let's just start by a brief description of your background and how you ultimately ended up at the Second Amendment Foundation.
Sure, we can do that. So was working at a gun shop while I was in law school. That was kind of a transition there. I'd gone to college. I majored in political science. Took a year off, wasn't quite sure what to do with life. At the time, I was working at a landscape company, kind of got fed up with what that looked like. Transitioned to a gun shop that was local where I got hired to actually cast bullets in the back. And from there, I ended up managing the place within about a month, which was kind of interesting. They never had a general manager before, and it really just came from kind of coming out and saying, well, why aren't we selling this or why aren't we doing that, and identifying opportunities for the shop to be more profitable and, have things that consumers would want. So it was during that time period I also had applied to law school because what else are you going to do when you have no plan in life? And so going into my last year of law school, I was looking for internship opportunities. And around that time, and before, I'd been hanging out on a Pennsylvania gun forum for a number of years, and I kept seeing this one name, Josh Prince. So I looked up Josh Prince, and it turns out he was about an hour from me. So sent him an email, asked if there were any internship opportunities, explained kind of what I was doing and where I was in life, and was able to secure an internship, which is where I ended up working for 5 years doing firearms related law once I graduated and passed the bar. So we did individual representation for restoration of rights, advising people whether they were prohibited, issues with background checks, denials, things like that, and also industry representation. So FFL revocations, when people were setting up licenses, advising them on that, ATF compliance, determination letters, the whole slew of things. And from there, we were hired as outside counsel for another group in the space. So the bump stock litigation, which was recently decided by the Supreme Court, not our case, but we filed the first lawsuit in the country on that issue back in 2018, and the following year is when I went to the nonprofit world at another organization within the space, started as the director of legal strategy, left in August of 2022 as the vice president of programs, made a few phone calls, and this was the result of that. There was no path or plan to get here. It just kind of happened.
You didn't set out to do this.
No.
You said something there, like when you were working at the dealer and eventually became general manager. Mm-hmm. I feel like that's one area that our dealers in the industry are getting much better at, is realizing they has to be run like a business.
Yes.
I think for a long time, it was hobby guys that got into it because they enjoyed the firearms, and they didn't really think they needed a general manager or, even maybe somebody in compliance. They thought they could do it all themselves. Is that kind of what happened?
So I think, in fairness to them, they had a pretty good business sense. I think it was a matter of the immersion in gun culture and what part of gun culture they were immersed in. So, like I said, I was hired to cast bullets. Okay. They were very big into the competitive shooting arena and particularly reloading. And so anything reloading, this was the shop to go to, still is in my area. But as far as, modern semi-automatic rifles, the different types of accessories, other things like that, new guns that aren't just what the distributors are kind of like, hey, you should check these out. Stuff like that is really where we started to expand the portfolio. We had done, one of the things we did was taught AR build classes at that time, which was something that nobody in the area was doing, and they were wildly successful. And it wasn't just how to assemble the rifle, but also the functionality of, like, what does this do? How does this interact with the other systems within it? Things like that. So it was a kind of a continuation, or I think around that time I was doing the YouTube stuff too. So it was education in a different facet, and that's one of the things that throughout life has been kind of whether intentionally or unintentionally, kind of important to teach people about either how it works, what it is, what it means, how it affects them, things like that.
When I think that becomes very evident in following you on social and reading some of your stuff, because a lot of times when we see these law cases, I read the headline and then I kind of scan the article, but there's so much legal wording and documentation and I kind of get lost. But like following you, you do a very good job of breaking it down and simplifying it for the average person. So I think you're in the perfect spot with Second Amendment Foundation. So we'll kind of move towards your work there.
Sure.
The one thing that I see with the 2A community when I'm out doing events and different things is when people start talking about pro-rights or pro-gun rights organizations, everybody automatically, or I shouldn't say everybody, a lot of people will go to like the NRA, and they kind of assume that all the organizations are the same.
Yeah.
Where I've learned that the Second Amendment Foundation is doing something completely different and in a different manner. Can you kind of elaborate on what you guys do and what separates you from some of the other organizations out there?
Yeah, I'd be happy to do that. So I think when people think gun rights, they think NRA, as you mentioned. And that's because NRA has held a monopoly in a number of ways, including that the mainstream media was always talking about them. So from a branding recognition, they're what comes to most people's minds. When you start to dig a little deeper, there are other groups out there, and the Second Amendment Foundation is one of them. And as you know, it's our 50th anniversary this year. And when SAF was founded, the whole idea behind it was how to elevate a case to the Supreme Court. So we're a 501c3, not a C4. So grassroots lobbying and lobbying generally are something that we just don't do because the IRS says a 501c3 can't do that, with some limited exceptions that we just don't bother with because why jeopardize it? So our work has always been concentrated on the educational component as well as the legal aspect of it and working within the court system. So early on, what we did was we worked very closely with a lot of scholars and lawyers that were well known in the space. And back in the 70s, you got to remember, like it was very small, to kind of strategize as to what are the things that we need to do, either from a research standpoint or a publication standpoint, whether it's law review articles or other areas, to start to build this foundation in order to get a case from A to B. So for the Second Amendment Foundation, our experience in the courtrooms and working with the lawyers, stems back over, at this point, 50 years. It's not that we've been suing people for 50 years, but our work has started 50 years ago in this way of trying to get from A to B on cases to the Supreme Court and more broadly just cases being elevated to higher level courts for better decisions. We also had started the Gun Rights Policy Conference in the 80s, which was a gathering of lawyers, scholars, activists, individuals that were leading the various state organizations as a way to really get together and coordinate efforts for advancing and defending, the Second Amendment. What's going on in your state? How are your tactics and techniques working out? What can you share with others as far as that? And then again, on the legal side, these are the strategies we're employing in these cases. You might be able to try some of these. This is things that the other side has done. And with the scholars, again, this is the type of research that we need, or these are the things that we've just recently researched, and here's the information from that. And, it'll be forthcoming in these articles, things like that. Pre-internet, obviously, where, word traveled a lot slower and you only had in-person meetings or newsletters or, God forbid anybody picks up the phone nowadays. But, and that continues to this day. So we still have the Gun Rights Policy Conference. And again, it's just another way to get together the people that are really at the forefront of, advancing, defending, and restoring the Second Amendment. But I think really our experience in the courtroom is kind of what sets us apart. We've been involved in over 260 cases since our inception. That's either cases that we filed, cases that we were paying for where we're not actually a party to them, for some reason or another, and then where we're also filing briefs in other people's cases, trying to help them win by providing the court with some information that they didn't have room to brief, because at the end of the day, it's great when it's the SAF case that gets the win, but at the end of the day, we're here to just win. So however we can assist that.
So a couple questions on that. One is the Gun Policy Convention. Is that open to the public or? Mm-hmm.
Yes. Yeah. So the Gun Rights Policy Conference is going to be September 27th through the 29th this year in San Diego. It is free to attend.
Okay.
So there is no admission fee or anything like that, and you get to spend the day listening to all these people that are at the forefront of this stuff. A lot of the lawyers litigating these cases, a lot of individuals from various state groups come. We'll use San Diego County gun owners as the example here because they've been very good to us as well. Okay. But they're a local group and they're very active in the activism side of things, where they work to get people elected to various positions within local government in order to, offset attacks on the Second Amendment at a very, small scale local level. But they've been very successful in that. So we'll have groups like that, leaders from groups like that, speaking as to, this is what we're doing. This is how you can get involved. These are things you can do in your state, information like that. So it really runs the gamut from everything from activism to the legal side of things to some of the scholarly stuff to media. We do have media representatives as well that come and speak. So it's we're currently working on the agenda. It's just one more thing on my plate that I got to work with. Fortunately, I have a great team that we're doing it with. It's not just me, because that would be a massive problem. But so anyway, to answer the question, yeah, it's free. It's open to the public. You can find out about it on the website. If you go to saf.org, there is a tab for GRPC at the top, and you can click that, register, and it has all the information that one would need.
Because I think that's one thing that a lot of people struggle with is, one, how to get involved, and two, how to articulate, Second Amendment positions without getting into a heated battle. Because I think, and you guys do an excellent job with your messaging, but I think that's one of the things that sometimes is an issue is we're speaking in an echo chamber or to the people that think mostly the same way we do, which is great, but to me, it's not going to bring those people on the fringe, and it's never going to convert somebody on the other side to even look at it from a different light. Mm-hmm. So can you speak to that a little bit about how your guys' messaging is different, where, you're trying to get some of those people on the fringe to maybe look at it a little bit differently?
Yeah. So I think it's twofold, right? I think people that are not necessarily, I think let's break it up into a couple of different groups here. You have those that are very pro Second Amendment. You have those that are very anti Second Amendment, and then we'll say you have everybody in between, just for argument's sake. So let's call it three groups. I think no matter what, the people that are very anti Second Amendment, short of them having some kind of life experience that causes them to really reevaluate their position on things, they're always going to be there, and it doesn't matter whether we as an organization talk to them, or me as an individual, or any one of your listeners as an individual talking to those people, that their mind is really going to be open for change. I think those people in the middle are a very different story. Now, whether or not they're receptive to the message from an organization versus an individual is, I think, a driving question here. So certainly the messaging we try to employ is a little bit of a softer tone. I think one that resonates better with people that, still drives home the point that we are tenacious in what we do, but maybe isn't so jarring that somebody who isn't like, yes, I'm 100% pro Second Amendment, isn't immediately put off by it either, or they think that, you're a bunch of loonies or anything like that. But I think where the real progress comes from on that is actually the individual touch, and not really coming from an organization. And one of the things that I've observed, and I've had this conversation with many times over the last number of years, but one of the things I've noticed is that typically people who are pro Second Amendment or gun owners, or whatever you want to call them, they operate on logic and reason. And when they're having these debates or discussions or arguments, here's a bunch of facts, here's a bunch of statistics. Logically, I'm right and you're wrong. And the person that they're usually talking to operates on emotion. Well, I'm scared of. I feel this way. And it doesn't matter what the statistics say or anything like that, because at the end of the day, I feel this way. And those aren't compatible languages. You're talking, it's like me speaking French to you during this entire interview and you not having a translator and your just eyes are bugging out of your head. And I can't speak French, so I don't know why I chose that as the...
Well, I wouldn't understand it anyway, so yeah, we're good.
Makes sense. But the point of it being that they're not compatible. And so when you're trying to talk to somebody that's operating on an emotional scale, and not looking at it through a lens of logic, reason, numbers, you're never going to connect with them in a way that's meaningful, because at the end of the day, they're just going to say, I feel. But I think more importantly, the individual has the opportunity for that outreach at a personal level. And if they can take that opportunity to help shepherd the person who feels a certain way, I think that's where that transition really happens. And I'll give you an anecdotal example that I gave the other day to someone else. I grew up in a house that wasn't pro-gun, actually probably anti-gun. I had a BB gun when I was younger. Nobody showed me how to use it. Probably did some stupid things with it. I learned to shoot in Boy Scouts, and that's where this all started for me. Stupid grin on my face. I turned 18, bought a shotgun, stuffed it under my bed. My parents found out about it because I think my brother snitched on me, and I was told to get rid of it. Didn't get rid of it. I turned 21, bought a handgun, got a carry permit. There were more issues surrounding that, but essentially, my parents were not happy at all, especially my dad. And I was maybe 23, 24 when he came to me and out of the blue asked me to take him shooting. Okay, let's go. And that stupid grin that was on my face at 12 years old was now on his face. Now, it didn't happen overnight. He went out and bought some handguns and decided a carry permit was something that he would do. But, there were questions about AR-15s and why would you need that? Or why would you need a magazine that holds more than 10 rounds and so on and so forth. But over the years, that opinion has shifted from why would you need to okay, I understand the utility of this and I understand why somebody would want this. And I think people should have this. Now, I'm not going to say that's going to happen in every instance, but what I found anecdotally through my experience is that taking somebody who at least has an open mind or asks the question and you give them a positive experience with firearms tends to change their view on it. They may not become advocates, but at the worst, they become neutral or just go like, okay, I'm not sure that all the things I've heard are a big deal. Now, mind you, in the instance, my dad, he was born in the Bronx, grew up in New Jersey, never had firearms in his life, couldn't understand why anybody would need them.
And I was just going to ask if that came from him, came from his parents, generationally,
Sure.
where, they grew up over 30, 40, 50 years being told firearms are bad. It's reinforced by most of the media many times. Mm-hmm. So it is a big gap to bridge to get them, to even open their eye. I give your dad a lot of credit because to even admit that, hey, maybe I do want to try that. And I think a lot of times if we can get them to the range that first time,
yeah,
and they realize it's not maybe what they've always heard.
Mm-hmm.
And we've had people who we've got to the range for the first time and they're like, no, I still don't like it. I'm like, I respect that. I can't force my opinion upon you.
Sure. But you can give somebody a positive experience and a differing perspective. And what I suspect, because I've never actually talked to him about it, but what I suspect is his opinion on guns was probably formed from what he saw on the news and what was consumed through various forms of media, whether it was TV shows, movies, or what have you. And, not growing up in a family that hunted, which was something that, I didn't do as a kid and he didn't do, and not growing up in a family where, firearms were for self-defense, which is, the staple of the Second Amendment.
Yes.
Wasn't shooting competitively, things like that. I could understand why somebody might formulate a viewpoint of that. But, again, that positive experience, I think once you lead somebody down that road, odds are, again, at the very least, hopefully net neutral. Best, would be they become advocates and get into guns. And occasionally you're going to find the person, as you said, that just their opinion is not going to change. But at least they were willing to try it and have the experience.
And that's where I think that messaging is so important, because if you come at them too strong, and I'm sure your dad would have been a very similar
Mm-hmm.
situation, they're only going to start defending their position more.
Yeah.
So I think that's critical. And I think, like I've said it multiple times, but that's where SAF does such a good job with their messaging and the way they do things. When you guys are looking at different cases, what's the criteria, and this is probably a loaded question, but what's the criteria of we're going to go all in on that one or pass up? Because I know it's expensive every time you guys get involved with a case, mm-hmm. and resources are limited, money, time.
People.
You already talked about your schedule.
People. Yeah.
People.
So there's really two buckets when it comes to cases. There's strategic litigation, and then there's what I call opportunistic. So the strategic stuff is where we sit down and we look at what the current legal landscape looks like. So how case law currently is shaped and how we want to shape it. So strategically, what kind of cases do we need to do to change the law as far as restoring the Second Amendment, or in some cases, defending against whatever, which is probably more opportunistic or reactive litigation. But strategic being, we want to go from A to B on something. What kind of cases do we need to bring to get, from A to B on it? So in that regard, those are cases that we look for and we specifically plan because we're trying to establish a change in the law. An example of that would be some of the assault weapons ban cases we have, particularly the one that we had filed in Maryland, where the Fourth Circuit had en banc said in Colby that these were not protected arms. So we intentionally filed a lawsuit where we knew we were going to lose in the district court because the circuit court precedent is binding on the lower court there. And said, this is a good faith basis in an attempt to change the law. And the idea being that eventually the Supreme Court will take one of these cases. So an example of strategic litigation, trying to change the landscape, whether it changes it only in that circuit or potentially at the Supreme Court where it's nationwide, that ultimately is the goal. Opportunistic litigation would be the kind where somebody knocks on the door, they call, they email, and they say, hey, I've got this problem. And we look at the problem and say, okay, yes, if we take the case, it'll help that individual, but also there's a greater public benefit to it so that their issue doesn't only affect them, but it affects, however many other people, whether it's in this particular jurisdiction or the circuit, or again, whether or not potentially the Supreme Court would be interested in it long term. So that's kind of the criteria for that. Not you have a problem and it's unfortunate and it's tough telling people, sorry, we can't help you because everybody wants help and some people need help, but you can't just take everything. You got to look at it from what can we do that's going to have the greatest public benefit. And then the last thing would be reactive litigation. And I hate to say reactive, but sometimes it is. In 2022, the Supreme Court decided Bruin. New York, a couple months or in anticipation of Bruin, gets ready and passes a law that says, okay, we're going to ban carry in all these places. Well, that wasn't on our strategic plan. It wasn't somebody knocking on our door saying, hey, I've got this problem. It was a state going, you know what, we're just going to continue to infringe on your right in a new way now that we actually have to give people permits. So that's another type of litigation that we'll look at and say, okay, yeah, we got to do it. And of course, there's a massive public benefit in that one because you're talking about the entire landmass of the state and tens of thousands of people affected by it.
So can you explain a little bit what the Bruin decision was?
Sure.
Part of that is, I think, for me, we live in a bubble where sometimes we'll just assume that everybody knows what the Bruin decision is. But I know we have people that listen to the podcast that they may not even be completely firearms people. Mm. So what exactly, and why is the Bruin decision so important? Because you hear that referenced a lot, reading different articles and, websites, whatever you may have.
So I think it makes sense for us to talk about Bruin by starting with Heller. And we'll give a quick kind of historical basis for this. So when we're talking about Second Amendment case law, there are some cases that did exist prior to Heller, but really the world kind of began in Second Amendment jurisprudence in 2008 with the Heller decision. And what Heller said was that, number one, it is an individual right untethered to malicious service. Number two, you have a right to keep arms within the home. It also does talk about bearing arms in public, and if you read the decision and take it at its face value, it says that that's a protected right by the Second Amendment as well. And then lastly, it says this is the test that the courts need to apply when Second Amendment challenges are brought before them. That's the text of the Second Amendment as informed by the nation's history and tradition. The day Heller was decided, and the Second Amendment Foundation filed a lawsuit called McDonald v. City of Chicago. 2 years later, the Supreme Court decided that one. And that one incorporated the Second Amendment against the states via the Due Process Clause of the 14th Amendment. It also reiterates some of the things that were said in Heller. But what does that ultimately mean? That's why we can sue various states, local governments, cities, etc. Before that, it was only as applied to the federal government. You get the Supreme Court talking about electronic arms in Catano in 2016. All we really need to take away from that is that essentially is that arms that weren't in existence at the time of the founding are protected by the
Okay.
Second Amendment. And then we get to Bruin in 2022. Now, Bruin was a big case for a couple of reasons. Number one, it really does talk in depth about bearing arms outside the home. So while Heller did discuss bearing arms, Bruin really, that's all it was about, was bearing arms. New York, the city of New York, on paper, had a mechanism for people to be able to get carry permits on paper, but in practice,
Nobody was getting them?
Nobody gets them, right. And so that was one of the big things, that there is a right to bear arms outside of the home. We already said it in Heller, but we're saying it again. And also reiterating the test that is applied to Second Amendment challenges being another very big thing, because from the decision in Heller through Bruin, the lower courts decided that they were going to create their own test. That's not what the Supreme Court had articulated. And so in doing so, what happened in a lot of Second Amendment challenges was that they would weigh the Second Amendment and the constitutionality of it against an interest balancing test. Does the government have an interest in this law? And based on the standards that are in these interest balancing tests, they would use the one that's in the middle, the intermediate scrutiny, and really there the government almost always wins. So the government almost always won. But we saw after Bruin was decided with the test, it wasn't a new test. They very clearly said in two parts of the opinion that this is the test. We spelled it out on Heller, and then again, like in blinking red lights, in case you missed it earlier in the opinion, we reiterate this is the test. So text as informed by history and tradition. And then, interestingly enough, after that opinion came out and more lawsuits were either being decided after the fact or some were even brought, you're seeing judges that were of liberal backgrounds, Democratic appointees that, had it been under the old test, you never would have won with, actually finding in favor of the challengers because this is what the court requires. So, but essentially, the cliff notes on that, and I apologize, that was a long diatribe. The cliff notes on it is Bruin talks about carry, and it reiterates the test that the courts need to apply in Second Amendment challenges.
Okay. Well, and I think that's important for people to understand, because I know even in the state of Iowa, we went from may issue to shall issue, I believe, and then now we have constitutional carry. But it came from certain people, no matter, even if they had 0 strikes against them, not being able to get a concealed carry permit.
Yeah. Yeah, the discretionary aspect of it, the subjective nature of the may issue, not the shall issue. And that's one of the things the Supreme Court took issue with, was the subjective criteria that was, good cause. Well, what is good cause? Where's that line drawn between what I think is good cause for somebody versus you think is good cause for somebody? That's very subjective. The court did say that objective criteria would be okay. Permitting fees, that permits are constitutionally, and it seems as if the Supreme Court, if there was a challenge to just permits generally, would uphold a permitting regime. But it can't be based on subjective criteria. It did say, excessive fees could be a pain point for municipalities or governments in the future. Long undue burden and wait times could be another pain point for governments as far as challenges being brought up against them and them being able to prevail. But I think that's kind of where we sit with it right now, is that, if you have an objective permitting system, that's probably not going anywhere anytime soon.
And another question I've had is, a lot of times you'll see Second Amendment Foundation, maybe Firearms Policy Coalition, or different organizations will file what from the outside appears to be a very similar sounding lawsuit. With resources limited, like we've discussed a couple times, and I'm sure you guys have reasons, but what's the reason behind that, multiple organizations filing what seems to be the same thing?
So it depends. We at the Second Amendment Foundation do pride ourselves on working with others and working well with others. Sometimes there is disagreement as to strategy. It happens. Sometimes there is also disagreement as to the venue to file the lawsuit in. And sometimes that disagreement also, ultimately creates an advantage. If everybody picked the same court to file the same lawsuit in, regardless of whether they're working together or not, you're going to be in the same district court, you're going to be in the same circuit court, and then whether or not the Supreme Court is interested is an entirely different story. So sometimes it's a matter of looking at it and saying, like, okay, we think the judges in this particular district and this circuit are better. We might have a more favorable bench when we go there than if we file it over here. Those are much easier when it comes to federal challenges and federal regulations versus states, because states you're limited to what's there. Sometimes it's just a matter of, groups decide that they're going to go file a lawsuit and haven't talked to anyone else about it. They just up and go, and that's their prerogative, right? They have their own ideas and members that they're responsive to. So sometimes it's just a matter of we all have a similar idea or plan on bringing a challenge, and somebody just decides, like, we're going to go file this on our own first or what have you, and that's the way it goes.
Because I think we saw that with, like, the pistol brace ban. Mm-hmm. There was multiple organizations filing different claims.
Yep.
And then from somebody not fully involved in the legal side of it, it was confusing as those rulings came out. Was it just the members that were exonerated? Was it?
So a couple things on that one. So actually the Second Amendment Foundation filed the first lawsuit dealing with that, and that was before ATF entered into rulemaking. So you may recall what ATF did was they had published this is the criteria we're going to use. And we had filed a lawsuit in, I think it was January of that year. I think they had published it in December or November. We filed a lawsuit pretty quickly after that. ATF then said they were going to go into rulemaking and actually go through the formal APA process, at which point we, spoke to the government and said, like, well, we might as well just kind of keep staying these proceedings, because there's no point in litigating an issue where ATF is going through the APA process and ultimately going to promulgate a rule and waste all your resources and certainly our resources. So they came out with the final rule. We amended our complaint and, continued our lawsuit. At that time, though, other groups did file their own lawsuits. The interesting thing to a degree is, it's actually kind of funny. You get during the Trump administration, and we're going to move off guns for a moment, all these lawsuits against his administration, particularly in the Ninth Circuit and judges from Hawaii, and nationwide injunctions. The reason I mention this is because the nationwide injunction aspect of it. Nationwide injunctions, the Supreme Court has really strongly hinted at that we're not fans of it, and that they probably shouldn't be a thing. So when we're talking about the pistol brace stuff, when you saw those injunctions coming out, the scope of them was narrowly tailored, and that would be to the individuals that were actual parties to it, the organization, and its members. So when those judges were issuing injunctions, it was as to, Bob Smith, John Jones, the organization that was the representative of that, and the members of that organization, not just across the board, we're going to wipe it out. That was during the preliminary injunction aspect of it. There was recently a lower district court that did decide this issue and found against the federal government, said that they violated the APA and that the remedy was vacature of the final rule, so that it would be vacated and thrown out. The government has time to appeal that decision, but assuming they don't, then as it applies to everybody, it no longer is in effect because it was vacated and tossed out by a judge.
And it can be a scary thing for gun owners, because if you're just a recreational gun owner that bought a pistol brace 3-4 years ago, mm-hmm. and you're not dialed into what's going on and everything, and I know this has been discussed many times, but it basically creates a felony, for a person that has zero idea they've broken any, law because it was legal when they purchased it.
Yeah. So braces never became illegal.
Okay.
Slight common misconception with that, and I know it's a pervasive thought. They were never made illegal. They never changed the status of the firearm technically. What ATF did was said, here's a bunch of criteria that you need to sort through to figure out whether or not we are going to say that this is a short barrel rifle regulated by the National Firearms Act and not a pistol. And their criteria was things that, if it has a magnified optic on it, and if it weighs over a certain amount, and, all these other things that were never part of what ATF even considered or looked at when it originally looked at the first prototype brace and said, like, yes, this is an accessory. No, it doesn't change the classification of the firearm, and you can attach it to that. It was once people started using them in manners that maybe were not what the designer intended, that ATF started thinking, okay, well, there's a problem. And then that resulted in determination letters or guidance letters being issued that would become public right around SHOT Show and cause all this industry drama. And then ATF, reversing course. Well, actually, we didn't mean what we said. Or maybe like an incidental touching to the shoulders where it's okay, but if you're intentionally doing it, and if you built it versus if you bought it, because if you look at the definition, and I blogged extensively about this, this was at the very beginning when I was practicing law, and continuing from there, but when this started to become a thing, but you look at what the definition of a short barrel rifle is, and rifle, it's designed and intended, and made or remade, with the intent to be fired from the shoulder. So if you, as a manufacturer, assembled a firearm that had a brace on it, and I went to a gun store and bought that firearm and shouldered it, did I actually make a rifle? Particularly if I didn't modify the firearm at all. I just used it as is. I would think arguably under the definition, absolutely not. Now, if I made changes to it, so on and so forth. But the point of it being that braces were never illegal. ATF's guidance has waffled back and forth, and now we're at a point where court said, yeah, after 10 years of saying that like these are okay, and now coming up with all these arbitrary and capricious reasons, and the final rule was not logically outgrown from the proposed rule you had published. Like, this is no good. It violates the Administrative Procedures Act, which governs federal rulemaking, and the remedy is throw the rule out. Can ATF go back to square one and do a new rule? It could. Will it? Who knows?
So for people that are trying to find out more, like, get some guidance on this without having to go in and read the ATF ruling in its entirety.
Yeah.
Is your website the best place, or what do you recommend for, the average gun owner that doesn't want to have to read,
Sure,
a 78-page ATF ruling?
That's a fair question. I would tell you that in this particular instance, no, our website's not going to be the best place.
Okay.
Because some of that just goes to straight like legal advice, and that's one thing.
I was just going to ask that.
Yeah, that's one thing that we as an organization don't provide to people generally is legal advice. Certainly information, and if there is information that we can provide, we're happy to do it because we think it's important. But that, particularly with what ATF had published, it was such a subjective criteria, and that's one of the things that a couple of courts picked up on was that like. The average person isn't going to be able to go through this laundry list of stuff and figure out like, okay, are you the federal regulating agency going to say that, yes, actually this is that counts as this and this is going to be a problem. And now you have a short barrel rifle all of a sudden when you had no idea beforehand. It defies logic and reason and what, how government should interact with people.
Well, and I noticed that even recently I had to read some of the state of Washington's assault weapons ban, trying to see if we could ship a certain product to a customer out there. And even in reading that, they're so opinionated and anti-gun in the way they word it.
Yeah.
But they say it as like it's a matter of fact.
Mm-hmm. But it's not what the law says.
It's not. It's almost like you're reading a anti-gun website. With what they were saying. So, and even in trying to figure that out, it became, I'm like, okay, I think we can. So then I try to find guidance and, ultimately it's on, like for us as a manufacturer, when we ship to the dealer, they have to abide by their state laws, but we try to help them out and eliminate a lot of shipping back and forth.
Sure.
Because nobody wins there.
Yeah.
But it's just
it's hard. I mean, and I'll be honest with you, there's sometimes, and you're aware because you introduced me. Like, I'm a lawyer. There's times where I read things. I'm not sure I understand what the heck they're trying to say.
I don't feel so bad now.
Right. No. I mean, there's times where I have to sit and read things several times before, okay, I think I understand. And the worst is when it's, see this section over here as defined by this section. And the next thing you know, you're looking up like 18 different sections of law because they're pulling things and just basically incorporating it into the new thing they wrote. And you're like, all right, well, I hope I have all the pieces of this puzzle to get the full picture.
Was it the frame ruling where they started doing the point system? They were gonna.
That was in the braces.
That was in the okay.
Yeah, that was in the braces.
Yeah.
Yeah. But that was exactly my point. Like they're putting that on you as an individual to say like, okay, well this Yeah, all right, that and this, and now we're going to add this all together, and well, okay.
Well, I'm sure they ultimately win at times because people are like, I'm not going to try to sit here and figure all that out.
Yeah.
I'll just abandon my idea of what I wanted to build or buy.
Yes, I think that's probably right. But fortunately, the ATF, had, at least as of right now, did not prevail in keeping that one around. So we'll see where that goes. So like I said, the government could still appeal that decision, and there's at least three other pending lawsuits against it. So I'm sure more judges are going to find against the government on that one.
Are there any like common misconceptions you find from even people within the industry of what we may think versus the way it actually is, or even the way lawsuits work? And are there a couple that stick out?
Why is it taking so long? Being the biggest. That one's probably the biggest. Why does it take so long?
Okay.
Or why is there no decision yet? This has been going on for a year and a half. Well, there's a number of things. Sometimes judges just don't want to touch it. It's a controversial issue. They don't want their name attached with it. They drag their feet. Sometimes, not always. And it's hard to like actually prove that too. There's no way of proving it other than anecdotally. Like, it's a touchy issue that, I could understand maybe why somebody doesn't want their name on it. It's not the only thing on their docket, being another major one. Judges have a lot of cases. The caseload is fairly big, and criminal cases, because there's a right to a speedy trial, take priority over civil stuff. So there's one more reason. Sometimes it's just, how long it takes to get things together. Briefing schedules, parties all the time make agreements with others like, hey, you need another 2 weeks because, you have other stuff going on, fine. Like we would ask for the same courtesy if we require it, not we're just going to go 2 for 2. But if we have a number of briefs due in 1 week, like we would ask for an extension in one, things like that. Not the end of the world, and then it also takes time for the judge and their law clerk to sit down and write the opinion on it. So speed is probably one of the biggest, I think, questions that I always get about it. Other misconceptions, the Constitution says. Well, yeah, it does say that. Supreme Court has also said X, Y, Z, but that doesn't prevent somebody from interpreting it slightly different. And this is really where it does become problematic. And I think, in the context of elections, I've said a couple times that if we have 4 more years of a presidency that is not, supportive of the Second Amendment, whether or not the Supreme Court composition changes, doesn't really matter because it's still problematic. If you look at how many judges Trump appointed and how many judges Biden's appointed in his term, they're about equal, all things considered.
Okay.
There's like about 600 district court judges, so the federal trial courts, about 600. I think they've each appointed about 200, if memory serves correct on that. I forget what the circuit court composition is, but they've each appointed about the same number of judges to the circuit courts. So.
Okay.
Point of this being is that you get a judge in a district court who gives a unfavorable decision, and it goes up to a circuit where the composition is unfavorable and they affirm that decision. Supreme Court doesn't have to take a case, as we well know, because we've for many years there's been lots of cert petitions of cases that could have been good ones that the Supreme Court hasn't taken. So if that's the case, then that becomes the law of the circuit. And that affects all of the people that are within the states that are comprised of that circuit. Ninth Circuit being like the biggest one. I think there's 8 or 9 states. I can't remember exactly off the top of my head. But, so when the Ninth Circuit makes a bad decision, all of the states that are under the Ninth Circuit, whether they're red or blue states, are bound by that law. So if your currently red state trends purple and then blue and passes a law that was upheld from, let's say, California, all of a sudden, like, that becomes a problem for you unless the Supreme Court steps in, or there's another challenge brought where the court, the circuit court hears it en banc and says, like, okay, actually, we're going to overturn that prior decision. And the only way that would really happen is if the composition changed. So I think that's an important point to kind of make, is that, yes, the Supreme Court, absolutely important, no question, but the lower court composition, if it stops at the circuit court.
And I assume that lower court is much easier for the president to appoint. Supreme Court, obviously, there's the hearings and...
Well, there's hearings for all of them. But they're, I would say, less controversial, certainly not nearly as much covered by the media. A point that was made the other last week that I was unaware of because I just wasn't paying attention, but I think Biden did have about 9 judicial candidates that were not favorable towards firearms that actually the Senate did not confirm about a week ago. So, it doesn't mean that they're always going to get confirmed. It's up to the Senate to do it. The president gets to pick them, but more often than not, they find their way through the committee and onto the bench.
Interesting, yeah. Because like you said, the Supreme Court gets all the publicity, and I think we overlook and forget about all the other judges they appoint.
Yeah. And I think the other thing that people also forget about is we're always dealing with 2 bodies of law. We're dealing with federal and state law. So a lot of times you'll find state laws being challenged in federal courts, like California's assault weapons ban, Washington's assault weapons ban, any number of cases that we're currently litigating, like any of the
like the magazine ban right now.
Yeah.
In California.
Yeah. So those are all being challenged in federal court, not state court. But I think what people don't necessarily think about is that sometimes state court might not be a bad place to challenge certain things. The federal Constitution sets the floor of what the right protects. And its state constitutions can provide greater protections than what the federal one does. So in some instances, there may be states, and they're probably not going to be the states that are passing these bans for that matter, but generally speaking, there could be states where the state constitution provides a greater level of protection, and bringing a challenge in state court. Now, of course, it's only going to affect that state. It's not going to be a federal thing, and it's certainly not going to go up to a circuit court where it's going to affect more than that state, but that's a different avenue to do it. And I think one other thing that, it's a major misconception, not about courts, but about the Second Amendment, is that the Constitution doesn't grant the right. There's a pre-existing natural right to self-defense and armed self-defense. The Constitution should prevent the government from infringing on that right. And I think a lot of people misunderstand. There's a shirt that I always hate whenever I see it. It's like, the Constitution's my carry permit. I'm like, well, actually, no, that's not how that works. But like, I get what you're trying to say. And I think it's important that people understand that the Constitution isn't giving us that right. It's preventing the government from infringing on a pre-existing one. And I think that should change how people think about it.
And I would guess a lot of people have a misconception around that.
Mm-hmm. Yeah, I think so. And that's just a lack of, our education system and civics.
So if somebody wants to get involved with the Second Amendment Foundation, I know we're involved as like a manufacturer, but on a personal level, because obviously all this is based around fundraising, and that's the root of it all. Unfortunately, but it's a necessary evil that you guys have to do.
Yeah.
What's the best way for them to get involved? Just go to your website, and are there multiple levels they can sign up for?
Yeah, so if they go to the website, saf.org, there's either a join or a donate tab. So you don't have to become a member. If you want to just kick us a couple of bucks because you're like, hey, you know what, I like your mission, but I don't want to be a member today, that's fine. There are different membership levels. We have an annual, a 5-year, and a lifetime membership, and a patron level membership. Those are, we're currently looking at those and figuring out how to revamp that membership program. But those are the different levels that are currently offered.
And I know something unique we're doing with you guys is it's our 50th year in business. It's your guys' 50th year. So we built this rifle that we're going to be auctioning off.
Yeah.
And I know I see a lot of companies that have jumped in and doing different things. Mm-hmm. Are those companies coming to you guys? Are they actively involved, or is it more you having to reach out?
So it's a little bit of both. There are definitely companies that are contacting us that are interested in working with us and doing stuff. And then, of course, we have companies that we already have existing relationships with, and that just is coming up in the course of normal conversation while we're reaching out to them, talking about other things that are of interest to them, or giving them updates on things that we're currently doing so that, like the individual who may be giving us money, if we have corporate partners, they want to know that we're out there working on behalf of defending and, advancing and restoring the Second Amendment. Because at the end of the day, it affects your business as well. If people can't exercise the right, you guys and other, partners of ours can't operate.
And that's a question we get a lot of times because we specialize in rimfires or 22s. People who may not know better will say, well, that doesn't affect you guys. Why do you care? And, obviously we care just from the fundamental side of it.
Yeah.
But I don't think people even realize that even though we're just building 22s, there's many states that can, because they have a threaded barrel, and semi-auto, they're considered an assault weapon.
Yes.
And people are like, but it's a 22. I'm like, well, I know this.
Yeah.
And I think that's where like the education side of it is just so important. As we wrap up here, is there one thing that you want our listeners to understand about either the Second Amendment Foundation or even just, I think what you pointed out in the Second Amendment earlier or the Constitution is a huge point. Was there anything that I missed?
I'm not sure that there's anything you missed, but I think the education, I would like to harp on that for a moment.
Yeah.
So as I think I said earlier on the podcast, we really have the organization has two parts of its mission. One is education, and the other is legal action. The educational component is something that we're actively looking at, building out more functionality there. I think generally speaking, when we look at the space and all the nonprofits that are in the space, there's a fairly big hole in the education component. And I think that's a gap. That is a gap that I'm actively trying to formulate a strategy and a plan to fill in, because I think, as we were talking about earlier, if you can give somebody the information that they can then disseminate to others, coming from me as the organization, people are just going to say, well, you're a mouthpiece for the, whatever it is, whether the gun industry or Second Amendment or what have you. But if it's coming from somebody that they have a personal relationship with, and if it's delivered, that information is originally delivered to the individual who might be using it, or is just maybe even generally interested. Let's just say somebody is interested in a manner where they can consume a complex topic, and it's delivered in a manner that's a lot easier than the complexity behind some of the things. I'm doing a very poor job of explaining this. I hope our program's better than this. But essentially, if you can distill things down to it at an elementary level, and then have where people are interested in learning more, it become a little more in depth, and that information is then something they can take and use in educating others. That's a massive win, and that's something that we're actively looking at a way to build something that can fill that void.
And I think if they understand it at a level that they feel comfortable talking about it, then they can put it into their words, their experiences, and they're not just regurgitating talking points that these people have seen a million times on social media. Or
talking points are useless.
Yeah.
Talking point, there's no authenticity in them. And I think your point there is exactly right. If you can take information, consume it, transition it into your own words, and then not repeat it, but educate others through that, that's worlds better than here's a list of points to use against your uncle at the Thanksgiving table.
Yeah. Like we talked about your dad earlier, that full circle, somebody being able to talk from that experience is going to be much more relatable to somebody currently on the other side.
Yeah.
Than, like you said, you're going to be considered a mouthpiece for the industry and
whatever it is. Yep.
And on our side, we're, of course we make our living that way. So you're going to say this.
Sure.
But if you can take the average person and, like I said, let them speak from their experiences, because back to your point earlier, it becomes emotion. And people can feel that whether they know it or not.
Yeah. No, I think the education, just generally, I think it's better for everybody that there is an informed citizenry, that they understand the basis behind it. I guess the last point I'll make on this is the further in time we get away from the adoption of the Second Amendment, and the less that those lessons are generationally transmitted from one to the other, you get people who go like, well, why do we need that? Who cares? Well, of course, they weren't, so they didn't just fight a revolutionary war. But as society gets further away and teaches these lessons less, people don't understand the reason behind it. But you only need to look into the world to understand why it's still relevant. Look at all the countries that are still enslaving people, or that where citizens do need the ability to defend themselves against a tyrannical government or whatever it is. And so the lessons transcend the time period. It's all still relevant. It's just a matter of, well, today, like we don't have that issue necessarily, at least on its face. But that doesn't mean it won't happen tomorrow. So why on earth would we give up this ability to defend ourselves, particularly when it's something that we as humans should have anyway?
I think that's an excellent point. There's people I follow on social media who have moved out of, communist countries, and they are so passionate about the right to being able to defend themselves. Mm-hmm. Because I think, to your point, they've seen it more recently. They know that it does exist, and we're not as far away from that as sometimes people think. So I've thoroughly enjoyed this, Adam. I think this has been very helpful, very informational. For everybody listening, if you want to, once again, the organization is saf.org. And I know I gain a ton of value following you on X. What is your account there? I think I like the way you distill things down.
Well, when I do that, it's at the Adam Kraut.
Okay.
Yeah.
We'll add that to the show notes. And for everybody listening, if you want to get involved, they're a phenomenal organization. We've been working with them for a couple years, and your money's being put to good use with their resources. Thank you, Adam.
Yeah, thanks for having me.
Thank you for listening. And if you ever have any questions or suggestions, hit us up at podcast@volquartsen.com.